Okay, good evening, everybody. Welcome to the University of Alberta's Visiting Lectureship in Human Rights. My name is David Percy, and I am Interim Dean of the Faculty of Law. I would like to give a special welcome to our guest speaker, Professor Adam Bodnar, and his wife, Magdalena Bodnar. We're delighted that they have been able to travel here from Warsaw to be with us this evening, especially in light of the sudden complexity in international travel that we've encountered of late. The University of Alberta acknowledges that we are located on Treaty 6 territory and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our community. The 30 banners you see on stage here represent the 30 articles of the Universal Declaration of Human Rights. As banners, they proclaim these articles and remind us of the commitments we all undertook as signatories to the Declaration in 1948. The University of Alberta launched the lectureship in 1998 in recognition of the 50th anniversary of the signing of the Universal Declaration. The inaugural lecture, as many people know, was given by Archbishop Desmond Tutu, and the university's continuing goal in offering this lectureship is to provide our students and the community with an opportunity to understand the complex issues at play in the world and to encourage all of us to address these issues. Since this annual lecture began, we've had opportunities to hear from lecturers who have contributed significantly to the promotion and advancement of human rights in a variety of contexts. The lectureship has provided us an opportunity to discuss controversial and often difficult subjects and provided an opportunity to learn, question, and participate in events shaping the world in which we live. The lecture we are about to hear from Professor Bodnar is entitled "The Fight for the Rule of Law in Poland," a topic of great current importance in Europe and in the world. Professor Adam Bodnar is the Commissioner for Human Rights of the Republic of Poland. He holds a doctor's degree and a master's degree in law from the University of Warsaw, as well as a LLM, a master's in law in comparative constitutional law from Central European University in Budapest. He began his career in the corporate sector. Then he worked for the Helsinki Foundation of Human Rights between 2004 and 2015. He became an expert in the Agency of Fundamental Rights of the European Union. From 2013 to 2014, he was the member of the Board of Directors of the United Nations Voluntary Fund for Victims of Torture, and in 2015, he was appointed to a 5-year term as Commissioner for Human Rights in Poland. He was elected to this role by Parliament thanks to unprecedented support and a campaign by more than 60 Polish non-governmental organizations. Professor Bodnar is a determined defender of judicial independence, freedom of the media, and minority rights for migrants, women, ethnic and national minorities, persons with disabilities, and sexual minorities. In 2011, Professor Bodnar was awarded the Tolerance Prize by Polish LGBT organizations, and in 2018, he and his office received the Norwegian Rafto Prize for the defense of minority rights and judicial independence in Poland. Last year, he received the Rule of Law Award from the World Justice Project. We are very honored to have such an eminent defender of human rights with us tonight. Please join me in welcoming Professor Adam Bodnar.
Ladies and gentlemen, it is my great pleasure and privilege to deliver a lecture within this scheme of visiting lectureship in human rights. I would like to thank Provost of the University, Professor Stephen Dew, and for this invitation. I would like to thank Dean for introducing me, and I also would like to thank Nancy Hanneman and her wonderful team for the whole organizational effort connected with this great invitation. I would like to concentrate in my lecture on the issue of fighting for rule of law in Poland. And I would like to start by just two snapshots. Here on this first photo, we see the first non-communist Prime Minister of Poland, Tadeusz Mazowiecki, who was elected as the Prime Minister after partially free elections in June '89, and the one who created the first independent government. On 12th September 1989, Prime Minister Tadeusz Mazowiecki made the inauguration speech at the parliament. So it is the photo from this speech made by a famous photographer, Chris Niedenthal. And among many important things, he said, "The logical and necessary consequence of the principles here presented and upon which the state should rest is the pursuit to build our state upon the foundation of law. The law cannot be an instrument wielded by the state apparatus or any other political group to exercise rule over the citizenry." End of quote. And the statement about rule of law was really important. Later on, changes to the Polish constitution have been adopted, and those changes introduced the principle that Poland is the democratic state ruled by law. And also this moment was important from the point of view of implementation of different state policies, including building of the market economy. Interestingly, one of the important first visits of Tadeusz Mazowiecki was to Canada. In April 1990, he asked for Canada's help in relieving Poland's foreign debt, and some part of this debt was owed to Canadian lenders. He said that the debt seriously affects Poland's experiment of moving to a free market economy. And importantly, as a result of his effort, but also of Leszek Balcerowicz, Lech Wałęsa, and a number of friends all around the world, so-called Paris Club has decided 1 year later to agree on a very significant relief, and it was important tombstone in reforming Polish market economy. As you know, later Poland was basically building the state of democracy, market economy. Poland joined the Council of Europe, NATO, and in 2004, the European Union. And basically, Poland was regarded in general as a success story all over the world. When we had the economic crisis all over the world, Poland was regarded as so-called green island in Europe, in which there was no even sign of the economic crisis. But let us take another snapshot. This snapshot is about the report of the World Justice Project. The report of the World Justice Project, a non-governmental organization that has been just released today in the morning. So right now, just after 30 years after the start of democratic changes in Poland, Poland is subject of the rule of law procedure in the European Union. There are a few judgments issued by the Court of Justice of the European Union concerning Poland and Polish judiciary. Poland is also the only European Union state which is included into the special monitoring procedure by the Council of Europe. Moreover, we have such symbolic moments like the protest by judges that recently organized 1,000 gowns demonstration in the middle of Warsaw. So according to the report by the World Justice Project, Poland is ranked as at the 28th place in the world concerning standards of the rule of law. There are 128 countries listed. By comparison, Canada is on 9th place in the world. But interestingly, when it comes to one of the points in this report, which is restrictions on the governmental powers, Poland is on the 51st place out of 128 countries. And basically, if you look into those reports, but also reports of other organizations, you can observe like the constant decline in standards. So if we look at those snapshots, we have to ask a question: how did it happen? Why such a dramatic change has been possible? What went wrong? Is it a part of the general trend, or maybe is it just a Polish case? And let me answer those questions by presenting the story of dismantling some elements of the rule of law in Poland. And it seems to me that this story is far from being over, and that the process is not yet completed. And in my opinion, it is not just a sad story to be repeated, but it might be also a warning, because there is a lot of resistance which gives a hope for the future. So first, I would like to present a trajectory of changes in Poland. And please accept my apologies that I will not give you all the details. The story is quite complicated from legalistic point of view, from constitutional point of view, from societal point of view. And it is not a story which is also good for Hollywood movies. Because the change did not happen overnight, because it was a long process, and because this long process ended to a situation which some politicians are naming in such a way that I don't even dare to repeat those notions. Let me look at the next slide. This gentleman here is Viktor Orban, who made a speech at one of universities some time ago, explaining what is the state he's going to build. He basically said that the state which is going to be built in Hungary is the illiberal state. So he used for purpose the notion of illiberal state, illiberal democracy. It says that the state does not deny the fundamental values of liberalism, such as freedom, but does not make this ideology the central element of state organization. And why Viktor Orban is important? Because Jarosław Kaczyński, leader of the Law and Justice Party, already in 2012 proclaimed that he wants to build Budapest in Warsaw. And basically he referred to reforms that were made in Hungary by the strongman Viktor Orban. Orban has managed to move the country from the constitutional democracy to illiberal state using parliamentary majority, but also using a possibility to change the constitution. He had Fidesz party had the constitutional majority. And also he managed to change the operation of different independent institutions by having, by those legislative and constitutional changes, and also by making so-called constructive dialogue with international institutions, especially the European Union. But this constructive dialogue gave a chance for Viktor Orban to implement certain changes. So even if there was a pressure to change something after some period of time, it was quite difficult to make it. And at the same time, Viktor Orban secured relative economic stability for Hungarian people, and he was highly efficient in using different propaganda techniques in his policies. So when Law and Justice came to power in October 2015, when Law and Justice won parliamentary majority, the Law and Justice Party didn't hide the intention to repeat the story of Viktor Orban. I would like to show you next slide, because it is the courtroom of the Constitutional Court in Poland. It is the photo which was taken by me, in fact, on 13th December 2016, when I was present personally, and I was standing to challenge one law before the Constitutional Court. Why the Constitutional Court is important? Because the process of changes in Poland started with the attack on the independence of the Constitutional Court, the major body responsible for judicial review, for the reviewing of the compliance of legislation and other acts with the Constitution. Please note that the Law and Justice Party didn't win the constitutional majority. Therefore, the process of changes in the Constitutional Court was in fact a mixture of a few legislative changes in the operation of the Constitutional Court and also some specific actions aimed at to achieve specific results. mostly packing of the Constitutional Court with new judges, but also with filling in positions in the Constitutional Court that were in fact filled in by the previous parliament, but simply the President of Poland refused to swear in 3 of the judges that were appointed by the previous parliament. As a result of all those different changes, once again, quite a complicated process, by the end of 2016, the new Chief Justice of the Constitutional Court has been appointed, and basically this moment is highlighted as the end of the independence of the Constitutional Court. And of course, the Constitutional Court is still operating. But the newly appointed Chief Justice of the Constitutional Court, Mrs. Julia Przyłębska, is to a great extent controlling the docket of cases, and there were different situations which you could indicate the manipulation with court compositions. So, according to some former judges of the Constitutional Court, this is a body right now which is more rather serving for legitimacy of different legislative laws, legislative bills passed by the ruling majority than as a real judicial review organ. Please note that the political subordination of the Constitutional Court was subject of close observance by international bodies. So, for example, the Venice Commission, the Council of Europe advisory body on constitutional issues, issued a couple of opinions on the operation of the Constitutional Court. Also, the European Union started its political mechanism, so-called rule of law, Article 7 mechanism, to control the situation in Poland. The issue has been raised by a number of politicians that were visiting Poland in 2016, but all of this, in fact, didn't change the situation. Because it was quite obvious, and in some of interviews Jarosław Kaczyński was not even hiding, that controlling the operation of the Constitutional Court is basically central element of being in power. Quite interestingly, in 2016, when the public attention has concentrated on the fate of the Constitutional Court, the Parliament has passed a few other legislative acts that increased powers of the state apparatus. So first of all, the office of the Prosecutor General was merged with the office of the Minister of Justice. So person who is in the government responsible for judiciary and for the operation of judiciary has become at the same time Prosecutor General. And it is quite interesting because we had this system until 2010. So the legislative change was not, let's say, such a dramatic from the point of view of the Polish constitutional law because we had such a situation for years. But interestingly, the Prosecutor General has received a number of additional powers to control almost any investigation that is pending in a country, but also a number of powers to have impact on individual careers of prosecutors. Let me take some water. It's quite interesting that number of important, integral, and really highly professional prosecutors have been also downgraded and removed from their positions. So, for example, one of them, like one of the important voices concerning the independence of the prosecutor's office, Krzysztof Parchimowicz, has been moved from the national prosecution level to the district prosecution level. So, by basically like three levels down the grade. So this reform was really important from the point of view of like the daily operation of the state. Second, there were some legislative acts that increased powers of secret services. Please note that, and in my opinion, it is one of the major mistakes dating back to last 30 years of transformation, that we never had a real professional democratic oversight as regards secret services. So even without this democratic oversight, powers of secret services have been increased. Third, the non-partisan character of the civil service has been abolished. And please note that it was always like a strategic decision of previous governments to create like the independent, professional, non-political civil service. Right now, it is not, we are not basically going into this direction, and this more or less like a French model has been abolished with a simple legislative act. And also there were some changes concerning the operation of the public media, public radio and television, which has a quite significant impact on public discourse because it people in different rural areas may receive the usually have access to public television and quite limited access to private television. But please note that all those legislative changes have been made just with legislative acts in the parliament. So they were passed by both chambers, then president signed, and that's it. So it was not possible to review those laws by the constitutional law. But interestingly, and basically this picture is about this, one of those laws has been checked by the parliament, by the constitutional court. It was this public media law. So in the judgment of 13th December 2016, the Constitutional Court declared that you cannot create like the additional body to appoint leading officers of public radio and television with the circumvention of the operation of the traditional constitutional body, which is the National Broadcasting Council. It was the case decided upon my motion. So the case was basically, so the judgment was good from my point of view because that is the reason we have the National Broadcasting Council to control public radio and television. So you cannot create any additional body to circumvent its operations. But what happened afterwards? This judgment has never been implemented. So basically, this judgment has been just ignored by the government and by the ruling majority. I wrote a number of letters to the Minister of Culture, to the Prime Minister, that maybe, you know, this judgment should be implemented. And basically, there is silence. There is no need because the operation of the public television and public radio is so important to interests of the ruling party that there is no, let's say, political motivation to change anything in an existing model, despite the fact that, that there is like binding judgment on this issue. So basically all of this, Constitutional Court, Civil Service, Secret Services, and public media situation, all of this changed more or less between 2015 and until the end of 2016. 2017 was an important year because in this year, ruling party started to dismantle judicial independence in Poland. Once again, this process was highly complicated. There were a number of different laws adopted. But I would like to underline that this process has been possible to be achieved due to following reasons. First of all, as I said before, it was obvious that the Constitutional Court will not be able to review any any legislative act concerning the judiciary. And second, if you ask any citizen of Poland whether Polish courts should be reformed, everybody would agree. Yes, they are coping with the backlog of cases, with length of proceedings, with, let's say, quality of reasoning sometimes of judgments, with lack of court experts, with lack of additional personnel to help judges. So everybody would agree with a statement that, yes, we have to reform judiciary. But interestingly, this argument has also been used by the government, but in order to achieve completely different purposes than just reforming judiciary. It was more about creating some kind of a political subordination of a judiciary. This process has not been yet completed, but it has really a lot of dramatic moments in meantime. So just to give you some idea, it is a photo which was taken in the cover page of New York Times from 2017, July of 2017, when we had like massive protests all over the country against the judicial reform in Poland. So basically, this protest was in connection with the new law that was proposed and adopted quite quickly in July 2017, which concerned the independence of the Supreme Court. Interestingly, at that time, the law that has been protested so heavily was about basically dismissing all the judges of the Supreme Court and giving the Minister of Justice a single individual power to select those ones that are staying in the court. So that was basically like the content of the whole law. But because of all those protests, President of Poland, Andrzej Duda, decided to veto the law. So it never entered into the force. At the same time, another law has been adopted, which was the law on the National Council of Judiciary. It is a major constitutional organ responsible for judicial appointments and for safeguarding judicial independence. By virtue of the Polish Constitution, the National Council of Judiciary is composed of 25 members, and 15 of them are judges. And they were always selected by peers, so by other judges. And the legislative change that has been proposed and passed in the parliament provided that judges, members of the National Council of Judiciary, will be elected not by peers, but by the majority in the parliament. The level of the threshold has been increased a little bit to 3/5, but still it was the parliament to select those members of the National Council of Judiciary. So basically, by more or less like a change that looked like a technical one, the process of nominations of members of the National Council of Judiciary has been changed, and it resulted once again in a political subordination of the National Council of Judiciary. Coming back to the Supreme Court, as I said, the first law on the Supreme Court has been vetoed by President, but later on, President himself proposed a new law, which was maybe not that strong in its substance, but still it led to the situation where 20 judges of the Supreme Court have been sent for early retirement. So by virtue of the law on the Supreme Court, the age of retirement for judges was 70. But the parliament has decided to change it to 65. And moreover, this provision applied not only to future judges, because if it would apply just to future judges, it would be in full compliance with the Constitution and rule of law standards, but it applied to existing judges of the Supreme Court. So as a result of this, 20 of them have been sent for early retirement, including, interestingly, the first president of the Supreme Court, Mrs. Małgorzata Gersdorf. But what happened? She protested. She said, I will not comply with the law, which is contrary to the Constitution. My constitutional term of service is 6 years. I'm going to finish this term in April 2020. I'm not going to go for early retirement as a result of the legislative provision, which I find as being non-constitutional. And interestingly, when the date came, it was the 4th of July, she was supposed basically to be on this date out of the court, but she decided to come to the Supreme Court and to protest by coming against this provision. So here you have an article from Financial Times when Professor Gersdorf, she's coming to the Supreme Court. She's in fact disobeying the legislative provision. She's relying on the Constitution, and she's greeted by thousands of Polish people in front of the Supreme Court. Later on, there are visits of international organizations, such as Amnesty International, visits of presidents of other courts supporting her in her role. And most probably, if she would not do this, most probably the Supreme Court would not be independent any longer. Because later on, this issue was subject of also of the decision by the European Union Court of Justice. But I will tell about it later on. But please note that one of the changes that have been also inserted into the law on the Supreme Court was the creation of two new chambers, the disciplinary chamber and the chamber of extraordinary control. The disciplinary chamber, it's quite interesting, was created to make like more accountability and more discipline to Polish judges. Interestingly, all the judges who are sitting in the disciplinary chamber are getting a remuneration which is 40% higher than regular judges of the Supreme Court, and basically this chamber has a very special status. And please note that right now we have like a big discussion, and there was also a resolution of all the other judges of the Supreme Court, whether this disciplinary chamber acts in accordance with the law, and just recently three other chambers of the Supreme Court have made like the joint resolution saying that basically they are not treating this disciplinary chamber as the new chamber, as the proper legally working chamber. So here you have a graphic which is composed by a graphic designer who created the Solidarity trademark. Niezawisłość, it says impartiality. And basically it is a photo of all the 60 judges that made recently a joint resolution joint resolution which clarified some rules how the Supreme Court should operate in Poland. Please note that the process of reducing judicial independence is not yet over, and certainly the adoption of some recent legislative acts, which we name commonly as a so-called muzzle law, is not completion of the process. But as of now, we can see that a number of institutions have been damaged as a result of those changes. The National Council of Judiciary, court presidents who are appointed, and some part of them were appointed directly by the Minister of Justice, disciplinary judges. There is also strong pressure on the independence of the Supreme Court, and there are also more than 40 regular judges that are having disciplinary proceedings due to their involvement in protests concerning judicial reforms, but also due to merits of their judgments. And those disciplinary cases cause so-called chilling effect on their adjudication. So basically, all of this is still pending. So we don't know yet what would be the end result. But as of now, we see how dramatic this change was and how many changes it implemented. But I would like to move forward a little bit with more, let's say, in my opinion, hopeful elements of my speech. And I would like to elaborate on some methods that were used by the ruling party in order to justify changes. But also I would like to concentrate a little bit on some resistance movements. So some people ask the question, why was it possible that this attack on the rule of law was so effective? I said already about one aspect, that the fact that Polish judiciary has not been fully reformed. And basically it is quite easy to argue that we need to reform judiciary. But we should also remember that the ruling party took advantage of a social stability and economic growth in Poland. So basically we have GDP growth for last number of years. Right now, 81% of Polish citizens claim that they are having middle or good level of life. And it is a remarkable achievement as compared even to some other Central European states. Moreover, the ruling party has invested a lot of money into massive social programs devoted to support families with children. And I think that those programs are good, and they were needed because they've built more egalitarian society. But also this social factor has been combined with some different vision of Poland, which addressed more martyrdom of Polish heroes during the Second World War, and also a vision of Poland as a state which is opposing some threats coming from other parts of the world. Please note that using this kind of a rhetoric based on fear, like for example with respect to migrants, is could be quite useful in Polish politics because Polish society is quite homogeneous. So the great majority of Polish people are Polish by origin and are Catholic. So therefore it is relatively easier for the ruling party to present itself as a defender of traditional values, family and Christianity. And because those social reforms had an impact on a number of Polish people, people at large were not so concerned with all those reforms concerning rule of law. But also we should be aware that there is a relative low level of civic awareness concerning the operation of independent institutions, their constructions, their role in the democracy, division of powers, and the value they play for the individuals living. So please note that the legal transformation started 30 years ago. So we've managed to make something like copy-paste of some institutions, like the Constitutional Court, for example. But I think we didn't spend enough time on educating people what is the objective of those institutions and why regular citizens need them. So it was much easier upon this background to make a strong attack on judiciary, also to use smear campaigns against judges, also by targeting individual judges. Please note that among those campaigns, some of them were even coordinated by people who were in the government. This gentleman here, his name is Łukasz Piebiak, and he is accused of, he was a deputy minister of justice, and he is accused of coordinating some actions that were undermining some individual judges and their individual reputation. He lost his position in the government for the involvement in this action. Quite interestingly, he's a judge by profession. We have a very strange system that judges could be nominated or rather delegated to work in the Ministry of Justice. So basically, this so-called hate campaign he did was subject of a lot of public attention 1 year ago. I think second point we should mention is that about when we are talking about those strategies is the strategy of making changes, but making those changes step by step by different legislative acts and by avoiding like a very direct confrontation. And even if this confrontation, that some of the actions are contrary to the Constitution, has been established, it was quite easier to explain to the public, no, you are not understanding, we have different interpretations, but in fact the change has been achieved. So I mentioned this example of the retirement age for the Supreme Court judges. This change has been justified not with the need to really reform the Supreme Court, but with the argument that we should bring the equality to all the judges. Because if the common court judges are going for the retirement at the age of 65, then it means that Supreme Court judges should also go for the retirement in the age of 65. So everybody would agree, yes, equality principle should apply here. But the end result was such that, as I said, those 20 judges have been sent for early retirement. Another strategy was a strategy of accomplished facts. By this strategy, I mean making changes, pushing, resisting the international and domestic pressure, and in the meantime achieving progress in dismantling a certain institution. So it seems to me that there is some similarity with Viktor Orban approach, and moreover, this approach gives some impression that there is some discussion with international partners, but in fact, the question is to what extent those discussions are made in good faith, and whether basically it is like the price which is paid. Because, and it is the part of the whole strategy that maybe if we take 2 steps forward, we can then later on take 1 step back, but still will be progressing in terms of dismantling judicial independence. Another important element is, in my opinion, such that the ruling party, when implementing some changes, the party was not trying to overheat emotions. So, for example, use of any physical measures, it seems to me, is heavily restricted. All those disciplinary cases against judges are made step by step. And there is like a strong propaganda justifying all those changes. So in fact, the only, in my opinion, mistake in that kind of narrative of making things like slowly was the adoption of the law on the Supreme Court in July 2017. So that moment when we had all those demonstrations in 200 Polish cities. So here you have a photo from one of those demonstrations in Poznań, the demonstration which was called popularly as the Chain of Light. And basically that was the successful demonstration. So we had all those demonstrations in all those 200 cities, and they resulted in the veto by the president. But I think one of the elements of those changes is also a very significant role of lawyers, because some of them became architects of change. They justified the most radical ideas of the ruling party. They drafted legislation. They defended it in the parliament. In social media and television, they promoted their vision. But we should also remember that there were other lawyers that were basically protesting, and they were against those changes. I said that about all those reasons, but we should also remember that sometimes there is a lot of discussion in international press that those changes in Poland did not concern only institutional dimension, that there were also additional so-called cultural wars underway affecting mostly women's rights, refugees, and LGBT rights. I always try to say that that we cannot take those issues separately, that they should be interpreted altogether, and that basically dismantling of the rule of law might have further impact on the protection of rights of different vulnerable groups, and that's why the rule of law is like the central issue in this perspective. I said that one of the important aspects of fighting for rule of law in Poland is resistance. Polish poet, Nobel Prize winner Czesław Miłosz in 1947 wrote in the moral treatise, I quote, "The avalanche changes direction depending on what rocks it encounters in its path." And it seems to me that people are like rocks. And if they take the constitution, rule of law, and human rights as granted, the avalanche may just go because rocks are flat and easy to overcome. But if people stand up to rights, each rock might be sturdy, massive, colossal, or even monumental. And it seems to me, I claim, that a number of people in Poland were like those sturdy and massive rocks. And I think that thanks to their effort, our reality is right now much different as it could be. And I would like to enumerate a few of those rocks, of those factors that contributed to resistance against dismantling rule of law. So I would like to start with civic society activism. Here you see this famous, one of those demonstrations out of so-called chain of light strategy. But there were also interesting demonstrations. It is once again photo by Chris Niedenthal with a very important statement, "To jest nasz sąd," which says, "It is our court." So can you imagine people, like thousands of people standing in front of the court, and they were shouting independence of judiciary or free division of powers, quite abstract slogans to made during demonstrations. But I think that what is important and what is quite special in terms of involvement of civil society, and especially involvement of lawyers into protesting, is that some of them faced not only the dilemma how to make protest, how to be effective in this, but also how to convince society that judicial independence is important to them. So it was a little bit, especially for judges, attorneys, prosecutors that were protesting, it was a little bit like the action that they were like acting like a sailor on the boat during the storm. So although it is difficult for them to navigate, you have to concentrate on repairing sails because they were neglected before. So what is the problem is that we didn't have any proper civic education between '89 and 2015. So it was quite difficult to convince people that they should stand up for the independence of judiciary, while people didn't have that much of enthusiasm towards courts and not that much of understanding what is the importance of the courts in their life. So here is one example of this. This guy here, he is a judge, Judge Arkadiusz Krupa, who is having something like the moot court during the music festival. So can you imagine music festival, a lot of mud, a lot of dirt, a lot of loud music, and there is a tent, in fact it is the tent of my office, in which there is like a moot court trial in which one real judge in a t-shirt is basically instructing people and they are acting like actors in one case. So it is one of many, many actions that were made by Polish judicial associations to explain to the public why judiciary is needed to them. Another important factor concerning this resistance is solidarity of lawyers. As I said, the ruling party has managed to convince some of them to be architects of change, people that were participating in this process, but still, majority of them, it seems to me, and it seems that they oppose to those changes. And interestingly, some of them refer to old traditions of solidarity. So, for example, in 70s and 80s, we had in 70s we had the Committee for the Protection of Workers. Right now, we have an umbrella organization which is called Committee to Protect Justice. And you have a cooperation of judges, prosecutors, attorneys, legal advisors, members of the academia that are working together to defend judiciary. And one of the last elements of this is the March of 1,000 Guns that took place in Warsaw just a couple of weeks ago. It was a very dramatic, it was a very special moment because judges decided to wear their gowns outside of the courtroom. Moreover, they invited judges from all over Europe to come and to participate in this demonstration as a sign of solidarity. So it is one of those examples how this solidarity basically works, and also you may find a lot of prominent lawyers, attorneys who are, I don't know, billing 500 euros per hour of their work, who are representing on a voluntary basis, pro bono basis, judges who are subject of disciplinary proceedings. Another aspect of this resistance is something what I would name as the birth of the constitutional patriotism. Please note, we have a constitution of 1997, 2nd April 1997, but most probably, if you say to any Polish citizen about constitution, we would usually refer, yes, we had the second oldest constitution in the world, just after the Americans, the constitution of the 3rd of May, 1791, okay? So basically, everybody remembers about the historical fact, but not about the existing one. But protests concerning the Constitutional Code and judicial independence in fact resulted in the birth of a constitutional patriotism, and full allegiance to constitutional values, principles, and rights became a trademark of those who protest against undemocratic changes, and the Constitution became a symbol of resistance. And so one of those symbols is this poster designed by Luka Rajski, a young artist, in which it says Konstytucja, Constitution, but please note two words, ty, which means you, and ja, which means I, are underlined, which says that the Constitution is for you and for me. So it is really important symbol to many people in Poland. Interestingly, Lech Wałęsa, I don't need to introduce him, is wearing everyday T-shirt with this, even at the funeral of George Bush, he had this T-shirt. But this symbol portrays something. It portrays that Constitution became important. I think it is important to mention that also my institution was part of resistance. The institution of the Ombudsman has been created in 1987, 2 years before the democratic transformation. It became a bridge between old times and new times. And basically, it appeared that different powers which the Ombudsman is having could be quite important to provide alternative arguments to those proposed by the government, but also in terms of using some legal arguments and strengthening some civil society organizations, but also some judges who are protesting. But I would like to concentrate a little bit more on judges, because judges were subject of a tremendous pressure over the last 4 years. They have been targeted as so-called extraordinary caste or elites that are far away from society and its problems. And politicians have used individual cases of judicial mistakes or violation of judicial ethics as examples of misbehavior, wrong moral character, and the need to reform judiciary. Some judges have been also targeted with disciplinary cases, but also with regular hate speech. I already showed this Deputy Minister of Justice who was behind scenes in some of those hate campaigns. Even recently, the first president of the Supreme Court has been named by the President of Poland, Andrzej Duda, as, I quote, shame. But please note that despite the pressure, judges showed significant personal courage and professional dignity. Some of them became, in my opinion, real heroes. And one of them was recently portrayed by New York Times. His name is Igor Tuleya. Just now he has a case of lifting his judicial immunity in order to press for criminal charges in the context of one case of political nature in which he was adjudicating. And the case will be heard by this disciplinary chamber of the Supreme Court, so this body I mentioned you before. But coming back to judges, it's important that if they created different forms of protesting, but please note that they risk a lot, because they risk that they could be expelled from the profession. And one of them, Paweł Juszczyszyn, has been recently suspended in his function in the context of one case in which he allegedly exceeded his powers. So basically this change is happening now. So we have already cases where there is like a real judge who just has been suspended and his remuneration has been reduced just because of his function. When we are talking about this resistance, we shouldn't forget about European Union. Membership in the European Union proved to be a crucial factor in saving some remnants of judicial independence in Poland. Please note that Poland is party of a number of international human rights treaties. ICCPR, European Convention on Human Rights, we are subject of monitoring by different bodies. But only the European Union mechanisms proved to be effective. Because thanks to the membership in the EU, the legal system connecting Poland and the EU resembles the federal system. Of course, nobody in European Union would name it a federal system, so you would use such notions like supranational system, but basically it works a little bit similarly. So it means that one of the key principles of the EU legal order is the obligation to respect so-called European values, which are democracy, human rights, and the rule of law. And second, in order to provide for the good cooperation within a so-called common market and also within a territory without, in fact, physical borders, you must create a proper cooperation in civil and criminal matters. You must secure proper judicial cooperation. So the organ which is basically supervising the situation when it comes to compliance with the European Union legal order is the Court of Justice of the European Union. And in 2018, the Court of Justice has issued a very important judgment in a Portuguese case, saying that in order to secure the so-called effective legal protection within the European Union legal order, it is the right of the European Court of Justice, European Union Court of Justice, to check the, let's say, the quality of the independence of judiciary in member states. So here is a photo of the Court of Justice. And this Court of Justice over recent years has issued a couple of important judgments concerning Poland. So for example, first to interim measure that was made in October 2018, all those 20 judges that have been sent for the early retirement could come back to the court to adjudicate. So without the interim measure by the Court of Justice, it wouldn't be possible. So they could come back, and they are, most of them are still judges of the Supreme Court. Second, there was a judgment of November last year, which created something like the set of criteria, something like a test to evaluate the operation of the National Council of Judiciary and the disciplinary chamber of the Supreme Court. And right now, basically, we cope with consequences of this judgment, and those consequences are not really yet clear to everybody. And finally, last Monday, so just 2 days ago, the Grand Chamber of the Court of Justice has made a hearing on, concerning a request for another interim measure. And this interim measure is about to suspend the operation of the disciplinary chamber of the Supreme Court. So we'll see whether the court will issue this judgment, this interim measure, but it would mean for the first time in the history of the European Union that one specific judicial organ is basically suspended from the operation. So it is quite interesting that Poland became the laboratory for the EU to test use of different rule of law measures. And most probably, Poland will be in future presented in handbooks as an example of interaction between the federal and regional level. But it is not about handbooks. It is about, and it is not about development of the legal history, but it is about like the situation which is happening right now in Poland. In some of the speeches which I made recently in the parliament, I stated that the threat concerning Poland is the threat of so-called legal Pol exit. What I mean by this notion? I mean that Poland may be still the member state of the European Union, but will not comply with those principles of judicial cooperation that exist in the European Union. Because all those principles of cooperation are based on the mutual trust. It means that judges, prosecutors from different member states are trusting each other. They are relying on themselves because they comply with the same standards. And quite recently, we had one example of breaking this trust. The court in Karlsruhe, the Landgericht in Karlsruhe, made a decision not to surrender a Polish citizen within the framework of so-called European arrest warrant scheme, because the court said that it does not have trust into the independence of the Polish judiciary. And I hope that maybe this judgment will be like a warning to Polish authority. Please note that when it comes to resistance, as compared to Hungary, Poland has still a lot of space for pluralistic debate on a number of issues. And although the space for this debate is shrinking due to pressure on civil society and the strong role of public media, civil society organizations, opposition political parties, public intellectuals, and some media provide a room for discussions. And basically, as a result of this pluralism, the ruling party over last years also has resigned from some ideas, being afraid of public outreach. But this pluralism has also been created thanks to the domination of opposition parties in big cities. In most of them, mayors are politicians affiliated with opposition parties. Moreover, after recent elections to the Senate, which is the upper chamber of the parliament, the opposition has a let's say, like a stronger voice in the public debate. But please note the Senate has an important role in providing for more diversified public debate, but it does not have a blocking majority, so it cannot stop some legislative ideas of the parliament. So here is a photo from the Polish Senate. It is quite an important photo for me because it was one of the nights we spent together with Judge Zabłocki, president of the criminal chamber, when basically the Senate was the only place to really speak up against some of the changes. But still, at that time, you could make only some kind of a statements, but you cannot even count on any deep reflection concerning legislative acts. So right now, this reflection in the Senate is much more different. So the question is, so I come to an end slowly. So what is the future of Poland? So the question is, what would be the future of the Polish judiciary? Please note that this process of dismantling judicial independence is not only a question of some relationship with other EU member states, but those judicial reforms have also internal dimension. They may lead to lack of accountability of state authorities, but also discriminatory use of legal procedures against political opponents, and steady decline of the rule of law in the rule of law standards in a similar way as it happened in Hungary. Please remember, I made this slide concerning World Justice Project methodology. Hungary is right now on 60th place in the world. So really, those standards declined heavily. So there is I think that depending on number of circumstances, reaction by the European Union, the resistance of the Polish society, result of political elections, we can think about basically two scenarios. In a negative scenario, this process will continue, and it will be a system, the system that will be created will provide for operation of different institutions, but they will become facade, and they will change the way how the system operates. Opponents would not be able to effectively compete with those who are in power. And of course, it will have impact on how judges think. So in my recent comment to the Economist, I stated that we can have a situation that in general, courts will operate more or less in a proper way, but if the judge would have a case of a political nature on its desk, the judge will start to think twice, okay? What is the possibility and what could be the consequence of this judgment? So recently, the leader of the Judicial Association, Justitia, Krystian Markiewicz, made a statement that, of course, judges will be independent, but they will be independent just one time, because after being independent, they will be moved to some other courts, or maybe they will have some strong disciplinary measure against them. And of course, that kind of a scenario may lead towards questioning of the Polish membership in the European Union, because the European Union is based on principles of democracy, rule of law, but also it may affect transatlantic relations, as well as the geopolitical position of Poland between East and the West. But there is also a positive scenario. It may happen that Poland will be back on the democratic track, but certainly this democracy would look different as it was before, because we will have to rebuild the justice system, we will have to unwrap reforms, and it may even take a generation to do it. And the most important point, in my opinion, is that we will have to assure citizens about coming back to the line of continuity as regards future development of Poland, about the continuity in terms of securing stability and deepening of the rule of law compliance. And if this positive scenario happens, then Poland would also have to play an important role in strengthening the European Union integration, but also in strengthening transatlantic relations, especially because of the fact that Poland is one of those success stories in the post-Cold War era. So maybe all those problems Poland is facing will serve as a kind of a warning for other countries. Of course, as of now, I cannot predict future, especially right now when we are facing quite a new challenge relating to our health. But I think that if you do not have this kind of a predictability, the only answer you may give is that you have to work hard in order to defend principles of liberal democracy. You have to use your imaginations and skills as much as you can, and you must really take responsibility for things that may happen. You must think twice about consequence of some of those reforms. And I must say that I had this privilege to be highly inspired by this gentleman. Karol Modzelewski, Professor Karol Modzelewski, he was a Polish hero who spent 8 years altogether in Polish prisons during the communist era. So he said that every generation has a certain price to be paid. And I think that there are many judges, prosecutors, lawyers who are paying basically this price, maybe for the sake of the better future. But I think what was important about Karol Modzelewski is that he was saying that rule of law is not a value in itself, and that building all those different institutions is not the value in itself. That when you are reforming the state, you must also take care about building some kind of egalitarian vision of a society. And that is something what I really like in his thinking, that on the one hand, he was criticizing previous governments that they were not thinking enough about egalitarian vision of a society, but at the same time he was defending principles of the rule of law, of independent institutions, securing the individual against the intrusion of the state. So I do believe that maybe in future his political vision will re-emerge, and when we'll come back to this proper, in my opinion, democratic track, we'll build also more egalitarian society, and in fact we will continue some of the elements of social reforms that were made by the current government. Thank you very much for your attention.
We have time for questions. Now, we have a slightly different arrangement for questions tonight. There is a person with a microphone on that side of the auditorium and a person with a microphone on this side of the auditorium. Instead of passing it along the row in a time-honored fashion, we thought in the interests of preventing any possible transmission of bugs, if we could ask you to stand up and walk over to the person holding the microphone, it might be better. So I'd ask you to do that. I'd ask you to keep your questions brief, and we're going to deal with them in another slightly different way. We'd like to take 3 or 4 questions at a time, and then Professor Bodnar will answer that group of questions at once rather than individual questions and answers one after the other. So if I could ask you to respect those rules, it would be terrific. And if you have any questions, please put up your hand and then approach one of our 2 people on each side of the auditorium. And it's very difficult to see from here, so I might have to invite our helpers there to tell us who's got the hand up.
Good evening, and thank you for your lecture. I ask this also as a professor of law here. One of the fears that I have regarding your final admonitions to be brave and stand up for the rule of law is that this leads to an inevitable politicization of judges as such, and Europe will approach what the US is seeing now of selecting judges due to their perceived conservativeness, liberalness, etc. Do you believe in a way back to, or a way forward to, an impartial judiciary?
Thank you. Here we are.
Yes, I'm wondering if Professor Bodnar could comment on the context in Poland, politically, socially, prior to 2015, before the Law and Justice Party was voted into power. Clearly, there had to have been enormous levels of frustration. There had to be disillusionment. There had to be a number of factors operating where people felt that the system wasn't functioning the way it should be. You've already mentioned the lack of egalitarianism, because it makes me wonder if the last statement about should a judge today be afraid making a political decision, was that also operating in the years prior to 2015?
And the third one.
Professor, is there any prospect of Poland leaving the European Union?
Perhaps Adam will take those three. I don't see another one immediately.
Okay.
If you could.
Okay. Thank you very much for very interesting questions. The first question, politicization of judges. You know, it is one of the major discussions we are having, because judges who are active in those judicial associations, especially leaders of those associations, they are trying to speak up against those changes, but they are also active, you know, some of them are active in social media, some of them are active in radio and television, and moreover, some of them participate in demonstrations. And over those years, we are facing different dilemmas. So one of the first dilemmas was to what extent a judge may participate in a demonstration. In my opinion, if the demonstration concerns some, I don't know, issues of, let's say, social programs of the government, it is not for the judge to be part of it. But if the demonstration concerns the very basic value of judicial independence, according to human rights standards, and there are plenty of them, judges may participate in those demonstrations. But still, it is not certain whether some of them will be penalized by using different disciplinary sanctions by those who are controlling the disciplinary mechanisms in a judiciary. Of course, I see this risk. I see that some of those judges became extremely popular, and it gives them maybe some kind of a future vision of their career, maybe even of some kind of a political career. But I will be the first who would say to them later on that it is a mistake, that basically they cannot continue their role as being, let's say, like heroes of defending the rule of law, but when the change comes, then they have just to come back to like a real adjudication, and they cannot continue to be in this role. And I think it will be important role for a number of leaders later on to explain to the people that you know, right now we come back to a real work. From time to time, we discuss the idea of creating something like elections of judges, so more or less like the American system. But it seems to me that we understand that it would not fit into the Polish legal culture, not mentioning the constitution, especially because the judge is elected for a lifetime. So we are having more or less like the German system in terms of selection of judges, and nobody wants to change it nobody wants to change the constitution concerning this. But for sure, you know, there might be some problems with perception, and I do believe that judges will behave responsibly if they will come to this moment. I think that it is they are facing a lot of criticism for their involvement, because that is something which makes a difference between Poland and Hungary. So in Hungary, when the change was happening, judges were not protesting. I know some of the Hungarian judges that are active in protesting, but they are constituting really like a very, very tiny minority. In Poland, the Judicial Association Justitia counts 3,000 members, 3,000 judges out of 10,000 judges. So which is quite massive and quite vocal. And it seems to me that there wouldn't be a reaction of the European Union if not their statement, not their actions. And one final point, because, you know, sometimes in the Polish discourse, when we are thinking, when the European Union and the European Union Court of Justice is treated as a kind of a foreign court. It's not any foreign court. Polish judges are also so-called European judges, so they have a right and obligation to use European Union law in their adjudication. So, for example, if you have any case concerning protection of consumers with loans, with abusive practices, basically you have to use EU law on the daily basis. But it also means that the European Union Court of Justice is our court. It is also not Polish court, but it is a court under which we serve. And I think that in this context, those actions before the European Union Court of Justice should be treated as being justified and not as being some kind of a political action. The second question concerning those the situation between before 2015. Of course, there were levels of frustration, especially because lack of this, let's say, vision of egalitarian society. Because, you know, we experienced after joining the European Union, we observed the continuous growth, economic growth. We experienced that people are becoming richer and richer, but somehow this wealth of the nation was not addressed to poorer regions, to poorer parts of the society, and there were a lot of people living in the state of poverty. Moreover, one of the practices that we could experience was the abuse of the labor law. So a lot of people were employed on the basis of so-called civil law contracts and not regular employment contracts. I think what was also missing is something like a vision of development. So I think that was a lack of kind of a political vision. Okay, where are we going? You know, sometimes I joke that after joining European Union, the major political objective for Poland was to organize successful championship in football in 2012. Really, but really, like over 3 years, we discussed about highways, about infrastructure, about new hotels, about some, you know, whether it will be like a successful European championship. It was, in fact, successful. We did it together with Ukraine, also in those regions where right now it wouldn't be possible because of the war with Russia. But basically, I think what was missing was something like, you know, like a deep vision saying, okay, we are going to be like next Sweden, or we are going to be, I don't know, Norway, but without oil, okay? Or maybe Finland, because we'll invest into like education of future generations. Or maybe, you know, Germany, maybe Netherlands. You know, I don't want to use like easy comparisons, but basically something like a deeper strategic reflection and also implementation of reforms that were the basis of it. And it created for a number of people something like a sense of disillusion. I would agree with this word, and basically it paved the way for the Law and Justice to win elections, and also implementation of different good social programs, especially at the labor market, and especially at this in terms of subsidies to families. I regret that the social housing program was not implemented, because it is something we really need in Poland. But still, even having all those possibilities, in my opinion, it didn't justify such deep reforms concerning the Constitutional Code or the Polish judiciary reforms that are basically threatening Polish future. With respect to judges, before I was working for a number of years in the human rights organization, and I had a number of cases before courts. So, for example, I remember that we had significant problems with the use of pretrial detention. We had problems with deep reflection on some issues. But problems I would see with judiciary were not such that they were subject of some, in my opinion, political pressure at that time. They were rather part of the, I would say, professional opportunism thinking, like, I have behaved in a certain way in order to be promoted higher. I could observe that kind of issues, and sometimes, sorry to say it, intellectual laziness on the part of judges. So I could see those problems, but they were not problems of like judicial independence from the point of view of impact by politicians on their decision making. I think that the last question is quite provocative one. I use the word legal poll exit. By legal poll exit, I mean a situation in which Poland will stop to cooperate, or rather other countries will stop to cooperate with Poland because of the malfunctioning of the judicial system and because of problems with the judicial independence standards. This Karlsruhe decision is the first sign of it, but I can imagine that, one day, if you have a judgment of the Polish court concerning the custody of a child, and then this judgment has to be implemented by the Belgian court, this Belgian court will start to consider, okay, was the court really independent? Moreover, lawyers from Belgium will use this argument against Poland and against judgments of Polish courts. We can think about investors that will not rely on the jurisprudence of Polish courts, and will also seek how not to respect enforcement orders by Polish courts. And this European arrest warrant is a really big issue, because every year we are making thousands of surrenders on the basis of the European arrest warrant. So when there are no borders in Europe, it is quite easy to go during one day from Warsaw to nice beaches of Spain or Portugal. You will not meet any policeman that would stop you. Maybe now you will meet because of coronavirus, but in general, borders are open. So basically, it serves not only tourists, students, and rentiers, but it also serves criminals. So it would be really like a very big hardship from the point of view of Polish security and Polish public order not to have a proper cooperation on the basis of the European arrest warrant. I do believe that Poland would never leave the EU. That is my answer. Thank you.
Thank you. Now the question.
Okay, sure. Professor Bodnar, thank you very much for your talk. I have to declare that I'm an engineer, so I look at everything as a systems. When you run a system, there's a cost associated with it. So obviously, I know the cost is really high to have the rule of law systems. And I got the impression based on your presentation that it's hard to convince the people of Poland to adopt these rule of law systems. Is it because it's very difficult to convince that there's the benefit, the social or economic benefit is high enough that they say, yeah, sure, we should adopt the rule of law system. So basically my question is like, is it really difficult to show them the benefit, the economic or social benefit of having the rule of law systems, essentially?
Here we are.
Thank you. As you were explaining the very concerning events in Poland, I just thought of a story I read in the newspaper here yesterday about the Canadian Judicial Council appearing at a parliamentary committee opposing a bill that would require judges in Canada to take training on gender-based violence and violence against women. And the executive director of the Canadian Judicial Council said this would be an infringement on judicial independence, that the government can't tell judges what they have to learn. And my question is, do you think that this is the same issue, the same type of issue that you're talking about, what happened in Poland, but sort of a different place on the same spectrum, or is what you're talking about Poland just very much different in kind as we talk about judicial independence?
And another question on this side.
Witam pana do Kanady I do naszej prowincji tutaj w Albercie. Welcome, thank you very much for your presentation. My question is, you've mentioned quite a few times the role of the media in not only the elections that brought the Law and Order Party to power, but the continuing discourse and maybe the polarization between the left and right in Poland. Once you lose control of the media, how well do you think this progress, maybe over a generation, to return to a rule of law in Poland will be possible?
And I think a fourth question.
Hi, Professor. Thanks. I'm taking a course at the moment, and we're sort of tracing the human rights commissions and how they're broken down and arranged here in Canada. And then I was curious about all of the judges that are protesting in Poland. Like, do you think, A, that's a good way to sort of teach the public in what's happening if there's confusion? And in terms of accessibility, like, does that create an opportunity to sort of teach and how to navigate that system? And then I guess it's not a fully formed question, but I just wondered about your thoughts.
The question concerning the economic benefit of the rule of law and how to convince people. I think we are facing a situation when a number of people do not experience like the direct consequence for their living from the point of view of the rule of law, of the rule of law crisis. So I mean that they do not feel that they are affected by those changes. Why? Because they have a pretty decent jobs these days. The level of unemployment is low. We have this economic growth, and they have this kind of a feeling of security. And there are some small parts of the population whose, for example, retirement benefits have been cut, or whose are having some problems with access to some social benefits, or who, for example, are facing some, let's say, trials with the ruling party or some institutions that are close to the government. But all of those groups are pretty small. So they cannot build like the convincing story. So if you are trying to argue to people that, listen, if you are having rule of law problems, it may mean that investors will not come to your country, or listen, if we go this way, it will end up in some kind of a bigger problem. It sounds to people quite abstract, okay? I make a comparison which is maybe not like 100% good, but I try to make a comparison to climate change, okay? If you are talking to people about climate change, some of them who do not feel like affected on a daily basis are saying, oh, you know, it's like a distant future, you know, we shouldn't be concerned. But why is it a problem in Poland? Because we had only, in fact, 30 years to build the system of rule of law. You know, we started democratic transformation in '89. Before we had a system in which there was no rule of law. And before the Second World War, it was also, there were just a few years, you know, when we had like the proper democratic system. So basically, it is not part of the, it seems to us right now that it is not something which is built like over years in order to have like a stability in the society. Okay, I remember, for example, statement by my father, who was just like a regular driver mechanic, and he was always like saying in '80s, "I don't believe in God's verdicts and verdicts of district courts." Okay, or we have such a like a TV series from old days, which says, "The court is court, but the justice must be on our side." Sąd sądem, a sprawiedliwość ma być po naszej stronie. Okay, so basically this is like deeply in the consciousness, in our mentality, that we have some kind of a, I wouldn't say disrespect, but something like mistrust into the legal system and like sticking to principles. So that is why it is much more difficult to explain. So you cannot you cannot use like typical statements. You must be much more creative. So if I may, one of the, in my opinion, most successful programs on creating this kind of a consciousness was the program developed by my friends from the initiative Free Courts. Wolne sądy in Polish, Free Courts. It is a group of 4 lawyers that decided in 2017, after all those big protests, they decided to record short movies, like 1-minute movie, with the participation of actors, celebrities. And basically it was like this. Those movies were like, please imagine that you are having some dispute with a neighbor, and your neighbor is somebody who is affiliated with the ruling party. And then you go to the court with this person, so please try to imagine what would happen if the judge is more or less under some political pressure. And those short movies were really very instrumental in showing to the people why this value of the independent judiciary is important. But still, with a very limited access to media, with a very limited funds also to develop that kind of projects in social media, you cannot just within 1 year to change like the whole mentality of the society. And that's why I use this comparison with this sailor who is repairing sails when the boat is going on. You know, that was like the big dilemma for judges how to do it. For judges and other lawyers, how to basically convince the society and at the same time to defend the value of judicial independence. I would like to refer to the second question concerning the Canadian Judicial Council. As far as I understand, there is sometimes this discussion to what extent you may impose on judges something like educational responsibilities, as far as I understand. So just to what extent you should push them to educate themselves into a certain direction in order to have like a deeper understanding of some social problems or some issues that are pending in front of them. And I remember that in old days, like before 2015, we had such discussions even in the Polish National Council of Judiciary. So I remember that that there was some hesitation, you know, whether to what extent a judge should just being, totally impartial, educate himself, and to what extent there should be some governmental programs pushing judges into a certain direction. So we had that kind of discussions, but they were more like on this very, let's say, intellectual and high level. Right now, we do not have that kind of discussions. Right now, what happens in the National Council of Judiciary is a support for the government. It is not any longer independent institution. It is the institution which supports the government, and the whole process of selection of those judicial candidates to the National Council of Judiciary was made in such a way as to guarantee the presence of judges that were more or less loyal to the ruling party. So there are a number of issues connected with this, but I think the judge who is having right now any problem with authorities in terms of disciplinary proceedings, he would, the last instance he would go would be the National Council of Judiciary. So there is like moreover, the National Council of Judiciary has been just recently suspended by so-called European Network of Councils of Judiciaries. So this is like the umbrella network associating all the councils of judiciaries, and they said that basically you do not respect guarantees of independence, and we suspend you as long as you will not come back to the real independence. So I think this, the Polish problems are really of heavyweight nature. When it comes to media, I think the question was how to create like a control of media when we would come back to the real situation. I think there is no other way as to create a system in which we would secure the pluralism of operation of the public media. So public media that were created after '89 and were later on constitutionally and legislatively regulated are having, let's say, advantage over other private media because they have access to the whole territory of Poland. Moreover, they have a public funding. Really quite, right now, even quite significant funding, but this is like another story to tell. But it means, but if they have a public funding, they have to perform so-called public mission, which means public mission is to get to the public the information about current events, about everything what is material, what is important in the society, also about different cultural events, even that kind of niche cultural events, about the life of national and ethnic minorities, just everything which would not find its place in the commercial television and radio. But the important principle is that they must be plural, so they must secure access of all different political forces. And the role of the state organs, especially the National Broadcasting Council, should be to guarantee this pluralism. So basically, if we come back to the moment when it is possible to rebuild the public media, we should basically come back to this model, which is just in the Constitution. But simply, we should secure, on the basis of existing experience, we should secure that it really operates this way and it is not subject of political subordination in this or the other way. When we are talking about, sometimes people because they tend to compare. You see, in previous times it was not all; they were also politicized. I remember I have one personal experience with public media. I remember that between more or less 2008 and 2014, I was really heavily involved into the litigation and explanation, public accountability for the case of the CIA secret prison in Poland. In fact, I was even cooperating on one of those issues with one Canadian lawyer because you had some, not a prison, but one small element of the whole CIA rendition program. And I remember that in those years, it was the journalist of the public television who was a major investigative journalist on this issue. And I didn't have at any time or anybody from my organization or from Amnesty International or from to go to public media to comment on this issue, to seek for accountability, to criticize the government, the prosecutors, and so on. Not at all. So for me, it is, but it was really strategic case. It was really important strategic case that affected the reputation of Poland, the governmental interests, and nobody would even think, about limiting access. Right now, I cannot imagine somebody who would go to, let's say, the public television and would criticize the Constitutional Court. Moreover, such person would never be invited even, So right now I'm having quite a long correspondence with the public television, whether there is so-called blacklist of people who are not invited to the public television. Of course, the public television is saying that there is no such list, but some people claim that maybe it does not exist, but there is somewhere like in the minds of editors and producers of different media programs. The final point about judges and teaching on human rights. I think that is what is happening, because judges, due to this pressure, they've understood that they have a very important role to play in a society, that they are really fed power, that they have a huge responsibility towards citizens. I remember that after judicial protests in July 2017, I've made such a statement, which was a little bit commented, that right now judges have a huge debt towards the society because they didn't deserve that kind of protests. And really, after 2017, you see like a huge transformation of maybe not all judges, but a big number of them, in terms of involvement in educational programs, in terms of going to those music festivals, in making different activities in schools, but also in terms of changing their communication, the way they speak, the way they communicate judgments to people. So they've understood that it is not the question of just being right in their decision on the basis of like a proper legal justification, but it is a question also of communicating properly to the society reasons and commenting in media, being open to media, and to comments on some individual cases. So I think this might be a good lesson for the future. So if we get back on this democratic track, I think it will be like a big lesson for next generations of lawyers and judges especially. Thank you very much for this question.
Well, thank you, the audience, for some excellent and provocative questions. I'd also like to thank Professor Bodnar for a very interesting and timely presentation. Given the instability of the eastern borders of Europe at the moment, it's particularly important. We're so pleased you were able to accept our invitation to deliver the visiting lectureship in human rights. We hope you'll accept both our deep appreciation and a small gift. Well, actually quite a large gift. I hope your luggage allowance is all right.
Yes, it allows.
Okay. Just put it here.
Okay, thank you. Of course. Yeah, thank you.
Well, just 1 more minute. It's been a privilege to share this evening with you. You remind us that in the 71 years since the Universal Declaration, we've made some incredible advances in the recognition of human rights, but also this is a time when they're under great stress, especially in the eastern part of Europe. So when we have this situation, it did actually occur to me, what part of your talk dealing with the role of lawyers in both encouraging anti-legal and constitutional measures and implementing them. We are in the situation at the moment, I was thinking back to actually I'm aware that Poland is a vibrant and raucous democracy, and long may it stay that way, and has a very contested election coming up. But it occurred to me to think back to the 1930s and the role of lawyers in a similar situation when Hans Frank, the butcher of Poland, was ordered to implement the final solution in Poland. He objected. He didn't object because he thought it was a bad idea, but he said, it's not legal yet. And of course, that took about 5 minutes to fix, and then he went off happily to his task. And the other aspect, which was deeply chilling, was to think about what happened to German courts between 1933 and 1938. It very much began with the situation, if you have a case with a political dimension to it, be very, very careful. And the stress of that caused most of the judiciary to turn over completely between 1933 and 1938 to be replaced by Nazi loyalists. So that was my immediate thought. While Professor Bodnar is here, we're keeping him very busy. Tomorrow, as part of Pride Week activities, he will be speaking about the assault on LGBT rights in Poland. That's at 12 noon in the Telus Center next door at room 134. Friday at 2 p.m., he'll be speaking about women's rights in Poland as part of the Wirth Institute's Central European Cafe. That event will be in the Arts Lounge in Convocation Hall. You're very welcome to attend these events, and you can find details on the Visiting Lectureship website at the University of Alberta. This lectureship would not exist without the generosity of many visionary citizens, corporations, and foundations of Edmonton who believe it's important to hear from speakers such as Professor Bodnar. So our donors, thank you. Your gifts have provided this wonderful annual opportunity for us to learn, to question, and participate the events that shape the world in which we live. And I would also like to thank the staff and volunteers who contribute to this organization of this event and for the many hours they've dedicated to it. I should add that Professor Bodnar will be going to an Edmonton Oilers game tomorrow night. I did want to provide a wonderful bit of Polish trivia. The Edmonton Oilers had a very star forward in the 1990s who was the first Polish player to play in the National Hockey League. Mariusz Czerkalski played for I'm a fan, played in the 90s, and he ended up at his NHL career having scored 215 goals with 220 assists over a 13-season career. But his second stop was Edmonton. So thank you very much indeed for being here. Thank you. One more I forgot to add, there is a reception outside. Of course, we expect to see you there, and you're welcome to be there. Despite my very bad example, we're not pursuing handshakes generally, and I'm not going to measure to make sure everyone keeps a 1 meter distance from the person to whom they're speaking, but please bear in mind the times we are in. Thank you.